because he knew that he was going to be positive for drugs. He knew that he was going back to jail, and he was scared. And I know, Your Honor, that's no excuse for what he did. But he did that, and then he absconded. He failed to appear.
In case number 22 CR 607, defendant is in court represented by counsel Melissa Blake. We are here today for purposes of a change of plea. The defendant was previously indicted in a 2-count indictment filed on August 5th of this year. The state made a plea offer for the defendant to plead to count 1, theft, a felony of the 5th degree in violation of revised code section 2913.02A1. It is my understanding that the defendant is going to withdraw his formerly entered plea of not guilty and plead guilty to count 1. As part of that agreement, the defendant agrees to pay restitution to him, and there is no agreement as to sentencing.
Thank you. Ms. Blake, is that accurate?
Yes, Your Honor.
Mr. Marconi, were you able to hear what the prosecutor just had to say regarding what she believes your plans are here today?
Yes, sir.
She indicated to the court she believes that your desire to withdraw your previously entered plea of not guilty to count 1, plead guilty to that charge, count 2 would get dismissed. You would continue the sentencing to a later date to get some evaluations completed, come back on a later date for sentencing, where there's no agreement at this time regarding what sentence will be imposed, aside from restitution is the only agreement. But in regards to what other sentence, there's no agreement. Each side's free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyers and the prosecutor and what you want to do here today?
Yes, sir.
Now, you would have been served with a copy of the indictment in this case. You would have gotten that. I don't know if that's up here. Well, there it is. You should have received that. Looks like in August sometime. Did you get that then?
Yes.
And you had a chance to go over that?
Yes.
Now, in that indictment, you're charged with 2 counts. Count 1, which is the count you're pleading guilty to, alleges on or about January 14th, 2022 in Mineral Lake County, Ohio, that you did with purpose to deprive Jerry Carroll, the owner of property, being a credit card, that you knowingly obtained or exerted control over that credit card without the consent of Mr. Carroll, who is the owner, or anyone else authorized to give consent. Again, the property is a credit card, which makes the offense theft, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1 here?
Yes, sir.
Any questions about that?
No, sir.
Now, count 2, there's a second count here. It's being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about that charge?
No.
Now, as far as possible sentences go, you're pleading guilty to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No, sir.
Do you have any other charges pending against you at this time?
No, sir.
If a prison sentence were imposed, in this case, upon your release from prison, you could be placed on what's called post-release control. We sometimes call that parole. If you're put on probation, you could get up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes.
Further, if you are put on probation or community control and you're violating the rules or conditions of your supervision, we'll have a hearing here in court to see if what's called a probation violator. If it's determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did at that point, again, it could be in the same range as I mentioned before, between 6 to 12 months. Do you understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want. Anything you'd like me to know or you want me to consider, your lawyer could speak on your behalf and recommend a sentence to the court. The prosecutor is also allowed to recommend a sentence to the court. Do you understand that?
Yes, that'd be great.
Sorry?
That'd be great, yes.
Do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just how I characterize it. It's a recommendation. I'm not required to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty here?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
All right, then, Mr. Marconi, any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No. Well, actually, there was one. Like, as far as the restitution thing goes, like, I know, like, I obviously can't contact the whoever, I don't even know who the guy was, but is restitution, like, is that, am I able to pay that, like, through the courts? Just, is that, like, on file or anything? Like,
You'll pay that
would that be able to be paid before sentencing or anything?
You can
like
if
that?
you want.
Okay.
You would pay that through the probation department.
Okay.
So you're going to meet with them, and if you want to make a payment towards that prior to sentencing, you just bring them. I think they want a certified check or whatever, cashier's check.
Yeah, I figured it'd be the right thing to do. So I think it was like $240 or something.
And I don't know the answer to that. There's an agreed amount, it sounds like, right?
Yes, so the total amount taken in this case was $240 in the victim's wallet. The bank reimbursed the victim the $240. He just had to pay the $26 and some odd change for a new driver's license. So that's what the state is asking for restitution.
26 something?
Yeah, and change. I forget the exact for the cost for a new driver's license.
Okay.
We're going to do at this point, the prosecutor here is going to explain for me what she believes the evidence would establish if we did have a trial. I need you to listen to what she says. So I'll have some questions for you about that.
Okay.
Ms. Leshy?
Thank you, Your Honor. On January 14th of this year in Mentor County, state of Ohio, the victim, Jerry Carroll, was shopping at Discount Tobacco. He accidentally or inadvertently left his wallet on the counter. On the surveillance footage from Discount Tobacco, you see a female pick up the wallet and move it down the counter. You then see a male, later identified as the defendant, pick up that wallet. Inside the wallet was a Chase Bank credit card, Social Security number, or Social Security card, and a driver's license. The Chase Bank card was subsequently used to purchase $240 in lottery tickets. Witnesses on scene do identify the defendant as being the man in the surveillance video. Warrant was issued for the defendant's arrest, and on June 16th, the defendant turned himself in on those warrants. He was Mirandized and interviewed. He admitted to being under the influence and to purchasing those lottery tickets, and he used that wallet and obviously that credit card without the victim's consent.
Thank you. Mr. Marconi, we're able to hear what the prosecutor just had to say regarding what she believes the evidence would establish in this case if we had a trial.
Yes, sir.
What, if anything, did you say about those facts? Are they true? Did you do what she said?
Yes. You know what? For some reason, that's not an issue, but for some reason, I don't remember a wallet. But I was high at the time, and like I said, for some reason, I didn't remember a wallet, though. I don't know why.
But you used the credit card to do that?
Yes, absolutely.
Very well, then, regarding count one, charging you with theft, a felony of the 5th degree, what is your plea to that count?
Guilty.
But we're going to continue sentencing on the order of pre-sentence report investigation, drug and alcohol evaluation, and a victim impact statement. I'll continue your bond at your own recognizance. What all this means, as far as bond goes, there's nothing more you need to do. I'm continuing the OR bond that you signed back at the time of your arraignment. Please remember, when you're released on an OR bond, you have to show up at all future court dates, and if you don't, that's a separate felony that you can be prosecuted for, which is actually more serious than what you just pled guilty to.
Yeah.
So it's obviously important that you show up at all future court dates. One of the conditions of your bond will continue to also be that you don't use any drugs. Be requested to provide urine samples. If you are and they come back positive, your bond will be revoked and a warrant will be issued for your arrest. You understand that?
Yes, sir.
All right. Is there anything else for the record then, Ms. Aleshi?
No, Your Honor. Thank you.
Ms. Blake?
No, Your Honor, thank you.
All right. Thank you.
Louis Marconi, case number 22 CR 607. Defendant is in court represented by counsel. You're here today for purposes of sentencing. We were last in court on October 20th of 2022, where the defendant pled guilty to count one, theft, a felony of the 5th degree, and the court referred the defendant for a pre-sentence report, victim impact statement, drug and alcohol evaluation, continued bond, and scheduled sentencing for November 28th. On November 10th of 2022, the defendant's bond was revoked after he provided a urine sample that was not valid, and then a subsequent sample that tested positive for buprenorphine and tramadol. And then on the scheduled date of sentencing, the defendant failed to appear as well, which another warrant was issued on that date. The defendant has since been apprehended, and the state's prepared to proceed with sentencing.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be brief. Mr. Marconi simply has no excuse for what he did, Your Honor. He He knows that he did a change of plea over 2 years ago. He did show up to probation. It was there that I learned.
He did show up to probation.
He
Oh,
did.
okay.
He did initially. And it was there that he submitted a false urine sample because he knew that he was going to be positive for drugs. He knew that he was going back to jail, and he was scared. And I know, Your Honor, that's no excuse for what he did, but he did that, and then he absconded. He failed to appear for his sentencing on this particular case. And for the last 2 years, I mean, he's been living with his mother, his father. I've spoken to his mother, and I know he's got some troubles, Your Honor. Not only troubles with drugs, obviously, but he also has some mental health problems. I'm going to ask the court to consider imposing a minimum sentence on this case. I know that the case is older. If there's one redeeming factor outside of the failure to appear, because he was out on an OR bond, he has not picked up any other cases, to my knowledge. I'm going to ask the court to consider imposing a minimum sentence in this case. Thank you, Your Honor.
Thank you. Mr. Marconi, you have the right to address this court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
I just wanted to say, not personal, Judge, as far as the failure to appear. The thing was, I just got scared when it happened. I gave the probation department a fake sample of urine. Now, even then, like when the day it happened, when she asked me about it, I didn't lie to her. I didn't want to start. I even told her I didn't want to start off the wrong foot with you. You know what I mean? Yes, I did give you a false sample because I was dirty and I knew they were going to put me in jail. However, I just all I wanted was ask. I from what I'm being told, it's not possible. But like, jail's not the answer for me. Okay, I came a long way from now until my whole life, really. And all I was asking for was a chance. I mean, I screwed up, throw the book at me, man. All I was asking for was a chance at probation. I feel like, to me, that's direction. You know what I mean, in my life. I just finished 3 years of community controls. Okay, and I'm sure you guys could probably verify that.
Where did you finish 3 years of community control?
Right here in Paynesville. I was Ronald Downs.
You were what?
I was on community control with Ronald Downs. I never one time failed a dirty urine. I was clean the whole time.
When were you on probation?
I was on community, or not community, well, it was, I don't know what they call it. Is it called community control and
In
parole?
municipal court?
It was in parole, I'm sorry. I thought they called it community control.
This is community control. You're
Okay,
on probation
okay.
here.
I have it, I was on parole, but I thought they called it something else.
He was on
They call it post-release control.
Post-release control, I'm sorry. I mean, I just did 3 years of that, no hiccups. I mean, I was clean the whole time, you know what I mean?
You weren't clean when you got arrested.
I've done everything these people told me to do. Now, I was taking drinks they said that I was dirty for something else, marijuana. Now, it could have been through drinks that I was taking, fresh water. I mean, they have a lot of different things out there nowadays. I don't know. Only drugs that I use is marijuana to this current day, which was very...
When you were arrested, you were positive for methamphetamine and amphetamine.
Yes, and I was doing that prior some time ago, but they have drinks out there now.
No, you tested positive just like 2 days ago.
I understand what you're telling me, Judge. What I'm telling you is they have drinks out there now they'll make you test positive for stuff like that.
Now with our testing.
Okay, well, I'm telling you, I don't use anything else other than pot. I haven't.
We're positive for marijuana.
I was smoking marijuana the morning we got arrested in my driveway. When the cop pulled up, just the morning we got arrested. What I'm saying is, I was just asking the court for a chance at probation. That's it. I want to make this whole big thing. I'm not lying to you about the drink. I don't know as far as what they had, whatever. I don't know how there couldn't possibly be marijuana in my system. But I feel like that would be direction for me, and maybe I need more direction. I did the 3 years post-release control, you know what I mean, and I got off, and maybe I wasn't ready. I don't know. I just feel like jail's not the answer for me. My family needs me at home. I need to be at home with my family. This has been haunting me for a long time because I couldn't get an ID. I couldn't do anything. ever since I had this warrant from November of 2022. And, you know, I don't want to
You turned yourself in.
Well, yeah. Like I said, I got scared. I mean, sometimes it's easier said than done. I don't know if, I'm sure you can understand that. Like I said, I'm being as genuine as I can with you. Like I said, I don't feel like jail's the answer for me. And I was just asking for a chance. I mean, that's it. All I was asking for. I mean, if you look at my priors, I've never not failed to appear. You know, I had no intentions on this even dragging out this long, honestly. You know, it's just my mind playing tricks on me, saying that I was gonna, you know, do something, and I never did. You know what I mean? My whole plan was to turn myself in a long time ago. My mother, my father, everybody trying to get me to do it. You know, they couldn't make me do it. Well, that's really all I got, Judge. You know, I can't sit here and plead and cry to you. I was just asking for a chance. That's it. You know, I was asking for a chance at probation. I can promise you would never see me again. And I'll do the probation. I'll do whatever you guys want me to do. I'll do it. Thank you.
Schwartz, anything else?
Nothing further, Your Honor.
Mr. Leshy for the state of Ohio.
Thank you, Your Honor. The state is requesting prison. The defendant has a lengthy criminal history involving drug offenses, but also theft offenses, similar to what he pled to in this case. He has 6 prior cases that resulted in 4 prison numbers, and even the defendant's conduct in this case has clearly demonstrated he would not be amenable to any community control sanctions and that prison would be appropriate. Thank you.
Keely, are you aware of anything with this PRC?
I have no updated information, Your Honor.
This court has reviewed the pre-sentence report investigation. There is no drug and alcohol evaluation because the defendant didn't show up for that. I've considered the facts and circumstances of the underlying offense, the nature of the offense. I've considered what's been said here in court today. This is all considered by the court in light of the purposes and principles of felony sentencing set forth. I have considered all that foregoing in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. I've also considered the factors in 292912. The defendant has a lengthy, very extensive history.
Excuse me, Judge. Just, you know, when I get in trouble. I mean, it's just what happens. I apologize. I'll burst.
Can I speak or?
No. That has a lengthy criminal history as well as juvenile delinquency adjudications. Goes back almost 29 years now. When he started as a juvenile and then continued as an adult and just year after year. He has not responded favorably in the past to previously imposed sanctions. There are multiple probation violations in the past and his record as well over the years. He has served multiple prison terms for multiple cases.
I was only on probation one time.
He has violated the conditions of his bond. He failed to appear for his sentencing and was gone for over 2 years. He was arrested. He tested positive for drugs. No factors indicate recidivism is less likely. In 292913B1, the court finds the defendant has previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's no way this court can make any finding that the defendant's amenable to available community control sanctions. I made a comment that if I put him on probation, I'll never see him again. I never saw him after when he pled guilty. I never saw him again.
So,
Can't assure that he's going to do anything when he's on probation. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 10 months. He has credit for 12 days he has served. He had 1 day of credit initially, and then he's been in for the last 11 days. I need to advise you upon your release from prison, you could be placed on post-release control in this case for up to 2 years. If you are and you're violating those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 50% of the maximum term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. The defendant's ordered to pay all costs. Is there any restitution issues with this?
Your Honor, as part of the plea negotiations, I had informed the defense attorney at the time that the bank had reimbursed him for the amount of money. The only thing he was at was the cost for a new driver's license, which was approximately $26.
Order restitution to the victim amount of $26. Is there anything else, Ms. Alessi, for the state?
No, Your Honor, thank you.
Mr. Watson?
No, Your Honor.